Can You Pass the Job Test? Newsweek magazine, 5 May 1986. Various forms of testing are once again becoming popular. Now, that statement, although written in 1986, we can actually look now and say that perhaps testing has become a standard sort of practice in many occupations. And the question that the article is asking, of course, is implicitly whether or not this is actually appropriate. We'll be looking at in the following articles what privacy amounts to, because any sort of job test which involves things like urine samples or blood samples or something along those lines could, and in many instances does, constitute an invasion of your privacy. So the question is, can an employer actually require you to take these sorts of tests? And these aren't tests, as you noted from the article, these aren't tests like your academic performance or some sort of skill or ability. Now, what's interesting about our right to privacy, which all these articles are dealing with, is that in the private sphere, that is in the sort of business, we don't have a constitutional amendment to privacy. Now, the Fourth Amendment of the United States states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That's what the Fourth Amendment states, but the Fourth Amendment only applies to searches by government agencies or entities. So if the federal government tries to come in and ask you to take a drug test without probable cause, it clearly wouldn't be held up in court. If the state did it, so if you're an employee of the state or the county or even a city, there would be good reason to suspect that that action was unconstitutional. But the Constitution, particularly the Bill of Rights, doesn't apply to individual interactions. So an employer can require that sort of thing. Many people think that there might be something questionable about this, that maybe there is some sort of protection out there. But from a constitutional standpoint, we don't actually enjoy the right to privacy when it comes to employment. Essentially what we have to say is if we don't like the conditions of employment, we should go elsewhere to find that employment. So the question, though, is morally speaking, can employers require things like drug tests as conditions for employment? And that's what the article is talking about. What sort of tests are employers asking their employees to take or their prospective employees to take? And we might ask the question on top of this, is this right? Forms of testing. As the article notes, there are a number of different sorts of tests that employers utilize before they hire employees. Many students of mine in the past have told me that they've been required, for instance, to take a polygraph test before getting a job. A number of them have said that their employers require random drug tests as a condition of employment or maintaining employment. Later on, we'll talk about things like genetic screening and personality tests. Personality tests were far more popular in the 50s and 60s, as the article notes. Genetic screening is probably the sort of screening of the future, given rising healthcare costs and things of that nature. But what forms of testing are there? Well, there's the polygraph test. The problem with a polygraph test, and the reason that a polygraph test is not admissible in court, for instance, is that we're not sure people can't actually lie to a polygraph. So the fact that polygraphs aren't 100% accurate or reliable means that they are not an accurate representation of guilt or innocence. So the question is, how much can or should an employer rely on the outcomes of a polygraph test? Drug tests are another one which I think most of us have heard of, and some may have actually had. Here again, there's a problem of accuracy. They may be 95 to 99% accurate. With 1 to 5 out of every 100 tested will produce inaccurate results. So while 95 to 99% accurate sounds fairly good, when you consider that if 100 people go in for a job, that somewhere between 1 and 5 of them will have an inaccurate result and be denied employment based on drug tests. Some studies rate the error at 25% false positive. I think we've all heard the sort of stories about people who have eaten papa seeds, for instance, or who have taken some sort of cough medicine or been on an antibiotic or something that generates a false positive on their drug test. Now, in some situations, obviously, they can produce the documentation and show that this is actually what's going on. In other cases, there might be things in their system which don't affect or impair their performance, and are used against them. So tests may not reflect current drug-induced impairment, but residual drugs in one system: THC, cocaine, marijuana. Some employers, for instance, use hair samples. Marijuana can stay in your hair, or the chemical attributes of marijuana can stay in your hair for something like 30 days. So even though you haven't done anything in that amount of time, it may still be used against you. Now, there's a whole separate sort of moral issue as to whether drug use in general in the privacy of one's home is actually an immoral act. One can understand being inebriated or intoxicated or high on the job, but the question is whether what you do in your private life ought to affect whether or not you can continue your employment. So should these only apply to those whose work has some sort of public safety issue, or should they be a general sort of test that all employees have to take? A number of people have made the case that to ask your everyday employee to take a drug test simply to find out if they're on drugs constitutes some sort of invasion of privacy, whether it's a legal right to privacy, at least, or it could at least be a moral invasion of their privacy. Testing continued. Other forms of tests that have been used in the past, and to some extent are still used, are things like personality tests. The problem with personality tests is that there are some individuals who don't do particularly well on such tests. Personality tests may be utilized by the military when deciding whether or not to allow someone into special forces or something along those lines. Police often use personality tests to get a handle on individuals, and to this day there's still companies that will use some sort of personality test. And the question is whether or not those are, again, accurate in some way or determine whether or not someone's going to be a good employee. But the bigger moral question is whether or not I should even be asking those questions, whether I should require people to take those sorts of tests. If the person has no problem in their background, if they haven't jumped from job to job, if they have never committed a crime or something along those lines, then shouldn't it be the case that that's a private issue? What someone's personality is like is pretty much something that I as an employer should deem irrelevant, provided that they do their job and interact well with their fellow employees. Genetic screening is the one, I think, which will most likely come to prominence in the future. Genetic screening can protect people from health risks, right? We're getting genetic screenings for Alzheimer's disease, for MS, and other sorts of diseases. So this is a good thing for people to find out, although some argue that maybe not a good thing to find out. But generally speaking, it's good to know what your condition is. But then again, this may also be used as a form of discrimination. So with the genetic screening, you might find out that someone is predisposed to a certain disease, which means the employer's health care costs may go up in the future, their premiums for their employees. Those employees which are predisposed to having heart disease, say, or Alzheimer's, may cost them money down the line. And so such employers may discriminate on the basis of genetics. So it could discriminate against homosexuals, women, and all those predisposed to particular diseases. Again, here we have the accuracy problem. While I may be predisposed for a certain condition, there's no guarantee that I'm actually going to get that particular disease. So there's something to be said here. I mean, there are a number of moral issues we can sort of derive. One, again, is a privacy issue. Is it my employer's right to know? Is that just the risk they take? Is that the sort of cost of doing business? Is to say that, yes, we have a number of diseases which run through a population. It's no one's fault that they have that predisposition. And so all employers should sort of look at that as simply a cost of doing business. Another thing we might say is that individuals or businesses shouldn't be responsible for healthcare costs, that we should have some form of socialized medicine or guaranteed medicine of some sort, such that it's not a cost to employers. So they shouldn't ask the question because it's none of their business from a privacy issue or privacy standpoint. It's actually a social issue, since any one of us could get this sort of from a very Rawlsian standpoint. Any one of us could be born with this arbitrary condition, whatever it may be, And so, as such, behind the veil of ignorance, many of us might say something like, I shouldn't be discriminated against based upon something I have no control over. But here again, the question is this something employers should be allowed to screen for and use as a condition of your employment? Privacy, Morality, and the Law, W.A. Parent. Parent's article is a fairly comprehensive examination of the nature of privacy. What Parent attempts to do is give a definition of privacy, tell us what it means to violate someone's privacy, say why we value privacy in the first place, for there seems to be all this talk about privacy and the value of privacy, and we should respect people's privacy. But why should we respect privacy? Why is privacy so important or so central to the lives of individuals? And so Parent wants to give some account of that as a justification for respecting privacy. And then he wants to note the moral and legal notions of privacy. What's the moral argument for privacy? What's the legal right to privacy? This is one of the probably few areas where law and morality do often intersect. So the idea that people have a right to privacy is normally not just the right as viewed from a legislative view. Can we find it in a constitution? Can we find it in legislation? Many times we view this as some sort of natural right. So there's this sort of cross between natural law and morality and legality. These things oftentimes intersect. So what Parent wants to do is sort of separate all of these things. Give us the moral account of privacy. What's our legal notion of privacy? Why do we value privacy? Definition of privacy. Privacy for Parent is a relative sort of notion. So it depends upon the cultural norms and existing practices of a society. So what counts as private value of privacy? Regardless of which society or culture we're talking about, once the bounds or the boundaries of privacy have been defined, privacy becomes important or valuable to the individuals within that society. So for instance, I might argue the following. Once I know what my society generally accepts as the sphere of privacy, or once I actively engage in defining the boundaries that others have as far as what they can know about me, then I can use those boundaries, or I depend upon those boundaries to protect me in some way. In other words, I recognize here's as far as others can go about what they can know about me, what information they can be privy to. And so within this sphere, I'm going to live my life the way I want. So privacy, regardless of how it's defined, is important to the individual. Privacy prevents others from obtaining personal, sensitive information that could be used to acquire power over us. So once I know what those boundaries are, whatever they may be, now I've got my private sphere. Here's where I know I can be safe in some sense. Privacy prevents then the scorn or ridicule due to intolerant views or lifestyles, habits, and ways of thinking. So here's that area of my life where I can explore what I or how I want my life to go. And what Parent notes is that privacy is part and parcel of the liberal ethic. That is a violation of the respect for persons. We also talk about liberal in the following sense. Liberalism minimally says that each individual has a right to decide how they're going to live their life, within certain boundaries, of course, and they have a right to revise that conception of their good life. So we can talk about each of us has some sort of conception of the good life. We have a career that we would like to have, or an occupation. We have certain hobbies or interests that we want to pursue. And all of that together makes up our conception of the good life. Now, we also recognize that even if we're planning now, if we're sitting here, if you're sitting at home or in a classroom and you say, I really want to be, say, an economist. And after taking a few economics courses, you realize this is the worst thing I could become. In a liberal society, or the liberal ethic notes that individuals should be free then to change their conception of the good life. What I thought would be a good career or a good major may not turn out to be so good for me. In other words, I may be wrong about my conception of the good life. What privacy does is allows us to sort of change our views. if we were under the constant scrutiny of others, if everyone could know exactly what we were doing, all the mistakes we were making, the thoughts that we had, this would severely impact our ability to act autonomously, to choose our conception of the good life. So this is what he means by part and parcel of the liberal ethic. It doesn't respect persons' rights to their autonomy, to think the things they want to think, to pursue the sort of things they want to pursue, without ridicule, scorn, or whatever. The moral right to privacy. Parents' essential argument for holding that privacy is a moral right stems from the value that privacy has to us as individuals. So the value of privacy establishes the moral right to privacy for those that value freedom and individuality. So assuming that you're concerned with things like freedom, otherwise known as autonomy, and individuality, that liberal ethic, that ability we have to decide for ourselves what sort of life we're going to have, and to sort of pursue that life, then because of that, as long as you value those things, freedom and individuality, we can hold that privacy is a moral right. It's something that when you violate that right, you do something essentially harmful to the individual. Now, the fact that privacy is a moral right does not entail that it can never be violated. So, as with any other right, sometimes that right can be trumped by other considerations. So, the right to privacy may be trumped by something like the right other individuals have to not be harmed. So if it requires that I violate your privacy to save someone's life, for instance, that may be a situation in which the moral right to privacy can be violated. Criteria of a wrongful invasion. If privacy has the value that parent says it does, and therefore grounds a moral right to privacy, then the next step is to define when privacy has been wrongfully invaded. So what Parent has essentially done, and as he mentions in the article, in previous accounts of privacy, there was always the question as to whether privacy itself was legitimate, whether it had been justified as a right that we have. Parent believes that tying in the value of privacy, showing just how important it is to the way in which we lead our lives, leads to the moral right to privacy. Once we've grounded this moral right, now the question is, how do I tell if my privacy has been wrongfully invaded? As was mentioned previously, privacy is not an absolute right. There may be times when we do have to override someone's right to privacy, and the question is going to be, under what conditions may I do that? So the criteria he puts out here are not sort of definitive of a wrongful invasion. In other words, it's not as if an invasion would have to meet all of these criteria or fail to pass all of these tests. It might be the case that it's a wrongful invasion if 3 of the criteria are not passed, or 4. So these aren't to be taken as literally it must fail, or the invasion for something to be a wrongful invasion must fail each of these tests. As Parent notes, it may be several of them. It may just be 1 in some cases. And also, what we should note here is that these criteria don't give us specific sort of ways of determining whether an invasion or whether someone's privacy has been invaded wrongfully, but we have to then argue each point. So, for what purpose is the undocumented personal info sought? So you say, well, why are you invading my privacy? What do you need this information for? The next question, of course, is that purpose a legitimate and important one? Well, okay, now we, of course, have to define what do we mean by legitimate and important. And different contexts will make different sorts of invasions either justified or not justified. This purpose may be legitimate in one case, in another it may not. Is the knowledge sought through the invasion of privacy relevant to its justifying purpose? In other words, while I might want to have this information, do I need it to justify the position? So, for instance, this information is necessary in order to protect some human life. So we might say the sort of things that we see at airport security now, or the Patriot Act, or some of the other things that the government is doing in order to protect us from terrorism. The question might be, many of those activities invade my privacy. Is the justifying purpose there? In other words, will this information actually do what it's supposed to do? Is this invasion a rightful invasion or a justified invasion because the purpose for it is actually a justified purpose? is invasion of privacy the only or least offensive means of obtaining the knowledge? So one might ask, look, there are a number of ways I might get information. The question is whether violating my privacy is the only or least offensive way of doing so. Well, if that's the case, if it turns out there are other ways that this information could be gotten without violating my privacy, one might argue that that's the course that ought to be taken, whether it's by the government or another individual. What restrictions or procedural restraints have been placed on the privacy invading techniques? So, can anyone simply claim that the information is going to save a life or protect someone? Or do they have to go through a procedure? For instance, do they have to go before a board or a judge or something along those lines? Are there procedures in place that ensure that when my privacy is being invaded, that someone other than the person doing the invading has looked over the case and said, which techniques? Is this gone through the proper channels or procedures? Because we want to make sure that we don't wrongfully go into this very private sphere of someone's life, which already, the argument has been made, has this extreme value for individuals. What protection is afforded the personal knowledge once it has been acquired? Well, here again, once information has been acquired, and once this has been collected, what happens to it once the information is done? What happens to information that's collected that isn't necessary? So let's say in the course of invading my privacy, the government comes across a number of things that aren't actually part of what they were looking for, isn't part of the justifying purpose of the invasion. So maybe they were looking for financial statements and came across personal letters on my computer. That information may have all been collected, not all of it used. What happens once the information has been collected? Is it destroyed? Am I ensured that others aren't going to be able to see it later? Are the records sealed? Are the hard disks erased or whatever? So all of these things have to be looked at. If the information can't be kept protected, if the procedures aren't in place, if there are less offensive means of getting the information, if the invasion of privacy really doesn't justify the purpose, won't lead to the outcomes necessary, or the purpose itself is not legitimate, then some, if not all of these, constitute a wrongful invasion of privacy. Purpose of the criteria. Criteria 1 through 4 of the previous slide, that is, for what purpose is the information sought, is the purpose legitimate and important, is the knowledge sought through the invasion of privacy relevant to its justifying purpose, and is the invasion of privacy the only or least offensive means of obtaining knowledge? Those first 4 criteria deal with the rationale. And essentially what we want to do is avoid gratuitous invasions of privacy. That is, when there is no purpose, when the purpose is less than compelling, when the personal facts have nothing to do with the justifying elements, and when the info could have been obtained by less intrusive measures. So really the first 4 criteria is simply to avoid what we call the gratuitous invasions of privacy. Unnecessary invasions. Those that are just there to get information, not because that information is actually part of the thing that's being looked at, or information that's relevant to the thing that we're trying to protect, say, keep individuals from harm or protecting the freedom of other individuals or so forth. So what those criteria for essentially, as we've already mentioned, is going over each of those criteria, is that they're put in place to avoid these gratuitous invasions. Purposes continued. Aside from the avoidance of gratuitous invasions, criteria 5 also deals with the actual invasion. So the first 4 are sort of the pre-invasion. Let's ask these 4 questions as to whether we ought to invade the privacy. Is this invasion of privacy gratuitous or not? Chapter 5 deals with actual invasions. Indiscriminate invasions occur when insufficient procedural safeguards have been imposed on the techniques employed. So the question is, and that's criteria number 5, what restrictions or procedural restraints have been placed on the privacy invading techniques? And so we want to ask, are these indiscriminate invasions, or have they been thoroughly reviewed, thoroughly justified to someone other than the person doing the privacy invasion? And of course, number 6 deals with how the obtained info is treated after the invasion. Is it protected? How much of it is released, and so forth? And so according to Parent, we want to use those 6 criteria and ask ourselves whether these are gratuitous invasions, whether they're indiscriminate invasions, and how is this information going to be treated once it has been collected. The legal right to privacy. The outcome of Parent's article is a critique of the contemporary legal notions of privacy. And what Parent essentially holds is that contemporary jurisprudence could have benefited from the philosophical analysis of privacy. Now, he takes privacy, the sort of classic examples of privacy come from the Griswold case and the Eisenstadt v. Baird. Just as a note, the V in here doesn't stand for versus, it actually stands for and. So it's Griswold and Connecticut. In the Griswold case, Griswold was actually a case of contraception between married couples. There was a law in Connecticut. How one enforced such a law, I'm not quite sure. But in the Griswold v. Connecticut, the state could justifiably imprison or fine married couples who were using contraception. And so in the Griswold case, the Supreme Court held that the law recognizes an implicit right to privacy. So what is this right? What's the nature of this right? Well, the law was, or Justice Douglas, who was writing as the book notes, didn't actually give a particularly strong notion of privacy. In fact, the privacy issue was sort of implicit in the decision. In other words, people implicitly had this right. Well, 7 years later, in a similar case, the Eisenstadt v. Baird case, equated the right to privacy, the right to make fundamentally important choices free from unwarranted government intrusion. The Eisenstadt case was also a contraception case, except this time it was between unmarried individuals. So in the Eisenstadt case, it was actually illegal for unmarried couples to use contraception. Now, what Parent sees as the fundamental problem here is that he's made a case for a moral right to privacy. As a moral right, it is not a derived right, but is a right we have. It doesn't follow from anything else. So if we have a right to free speech, there's that right. Along with that right, there would be the right to privacy, and there would be a right to not be harmed and so forth. The way in which the courts have interpreted privacy is to make them derivative. In other words, the right to privacy isn't a fundamental right that we have. It's one that sort of comes from liberty. In order to have freedom, you need privacy. And so many cases, as Parent notes, conflate the right to privacy with the right to liberty. Parent does, in fact, have a problem with this. When you mix up a right to privacy with the right to liberty, what you're saying is people don't actually have the right to privacy, or if they do, it's only because they have a right to liberty. If there wasn't an issue of liberty, so if there wasn't a liberty issue, a freedom issue, then privacy is not important. And what Parent thinks is that the courts have missed this. They've missed the sort of fundamental nature of a right to privacy. You have a right to privacy and you have a right to liberty. Sometimes the two intersect, sometimes the two are related, but we can pull those apart and say there's a distinct right to privacy, and say the Griswold case, that married couples can engage in contraception because it's their right, not because it's a liberty right, not the liberty to use contraception, but because that's a private matter. And the Eisenstadt case could similarly be decided. The court could have held that there is a right to privacy, not a right to liberty to make choices about fundamentally important choices free from unwarranted government intrusion. It might simply be the case that there, again, individuals have a right or a sphere in which they can pursue their conception of the good life without government intrusion, without making any reference to what it is they want to do. And so Parent thinks that the courts have just been mistaken about this, that they've mixed up the right to privacy with the right to liberty. They've made one derive from the other. In other words, privacy derived from liberty. And what he's saying in the article, and at the end, if this seems to be confusing, this is what he's trying to do. He's trying to pull the two completely apart. There's a privacy right, there's a liberty right. They are two separate and distinct rights.